We're simulcasting out to multiple locations. So when a question is asked, you will hear us repeat it so our viewers online can hear it as well. But we have Beth Coonan here today with BrownWinick. She's donating her time to be here. She's a wonderful attorney, but also a very good friend of mine who has volunteered to do this today. She actually serves as the chair of BrownWinick's employment law practice group over there, and she specializes in the areas of employment workers, compensation, business immigration law. She assists employers with policy development and enforcement, non-competes, other restrictive covenants, business visas, compliance with immigration law, litigation and workers' compensation strategy, and she provides training on drug testing, harassment, and FMLA issues. So I'm going to go ahead and turn it over to Beth so we can get her expertise today, and we'll take it from there.
Well, thanks, Christine. I appreciate the warm introduction. So let's go ahead and just get started because we've got quite a few things to cover. I want to start by talking a little bit about just sort of the general things that you guys are all called upon to look at when you are faced with a situation where you have to discipline or terminate an employee. It's not just a simple, are they good, are they bad, how do I get them out the door? There's this patchwork of laws that we have to consider when we talk with our employees, when we communicate with them, when we communicate these tough decisions, when we deliver information about their performance or their conduct. And we're looking at things like the ADA, which covers disability. It protects employees from being discriminated against because they're disabled. The Age Discrimination in Employment Act, right? We don't want to discriminate against anybody who's over the age of 40. The Equal Pay Act, we have to pay women and men the same amount for the same level of work. The FLSA, that's what governs your wages, right? Your overtime payments and your minimum wage. You've got the FMLA. If you're a larger employer over 50, you've got to abide by that and make sure that you're giving your employees 12 weeks of job protected leave. That certainly can come into play if you're looking at a discipline or a termination situation. You've got genetic information. We protect that. We can't use that information to make decisions about discipline or termination against our employees. Then we have the Iowa Civil Rights Act, which is what's going to apply to a lot of our smaller employers as well as the large employers. But that's basically our general civility statute in a way. The law basically says that we can't discriminate against somebody because of their age and their race and their creed, their color, their sex. Sexual orientation is protected. Gender identity is protected. That's sort of our general law that we operate under here in Iowa, but it also mirrors in large part our Title VII statute, which protects employees from discrimination based on race, color, religion, sex, or national origin. We've got a whole bunch of other considerations to make too. We've got OSHA, which is safety and citizenship, right? We can't hire people that were authorized to work in the United States. A big topic these days. Pregnancy, we can't discriminate against somebody because they're pregnant or they're suffering from a condition of pregnancy. Military service, and then we have this sort of nebulous wrongful discharge in violation of public policy. So, for example, if you have somebody that maybe calls into question one of your business practices or they blow the whistle, generally speaking, we want to talk through those types of discipline or discharge situations before you go ahead and execute because it can create some liability for your business. So before we kind of move into the top 5 things, I want to give you a little bit of flavor for why I think it's important that we have this general conversation about discipline and discharge. And maybe you've cracked the code on this and that's why you're here. But, from my vantage point, we see all sorts of things. We see examples of, employers acting in really great ways, and we see examples of employers acting in not so great ways. And I think unless you're living under a rock, you've seen the news, right? We understand there's a whole bunch of stuff going on out there, and it's all getting publicized. The Me Too movement, the sex harassment stuff. We've had a couple of cases locally that I think are really important to mention because they illustrate the fact that it's not just happening outside of the Midwest. It's not just happening outside of Iowa. It's happening within our own borders. So here's an example I'll give you. There was a situation with a company where there was a supervisor and he was engaged in some pretty inappropriate conduct, right? He was telling his coworker, he was calling his coworkers breasts by different names, calling them the twins or saying these puppies. He would discuss her attire with other coworkers. He insinuated to other employees that he could get this woman into bed. He spoke at work about strippers. He, sent around, unwanted pornographic videos. He told this woman when she reported to him that she needed to leave work early to go get a mammogram, he basically told her, well, if you sat out in the parking lot, you could probably make some more money. We hear these comments in the workplace. I think we know, and I can judge by the looks on your faces, inappropriate, right? But they get said, and sometimes when they get said in isolation, I think as employers, especially small business owners, when you're trying to run your business and you're trying to turn a profit and you're focusing on your sale or your service, it's easy to overlook those one-offs. But in this particular situation, the effect was cumulative. And this ended up going to trial, and I think it's on appeal now, but the original verdict, I think, was about $1.4 million. So I tell you that just to illustrate that these are things that we have to just be careful about. And so that's why I'm talking about why we ought to use some best practices when we're communicating with our employees and talking about discipline and discharge. Okay, so let's get to the meat of this, the 5 things that you need to know. So I've gone ahead and just tried to boil it down to the things that I think are kind of the most bite-sized and the sort of the biggest bang for your buck items, right? So quality communications with your employees, obviously key. We want to make sure that you have policies and that you're following them. That when something's raised to your attention, you're actually looking into it. You're conducting a full and fair investigation into the circumstances. Or if you're not able to, or if you're the one who's the subject of the complaint, maybe you're seeking some outside help. And so we're going to talk a little bit about when to do that. We're also going to talk about how to maintain good documentation, which I think is one of the hardest things because, again, you're still trying to run a business. And then we're going to talk a little bit about retaliation because we're really seeing a spike in retaliation cases. So generally speaking, I think we come at this from the standpoint of, employers are required to provide a workplace that's free from illegal harassment, discrimination, and retaliation. So when I look at number 1 and I think about communication, we all hear sort of the general statements, communicate with your employees because then they understand what what you want, right? And I created this myself, by the way, this crude infographic. I hope you're all impressed with it. It took me about 20 minutes. That's how tech savvy I am. I need to come to Christina's next top 5 on tech. Okay, so when we set forth our expectations for our employees, it gives them a certain level of comfort. And it's our hope, of course, that it drives their conduct, right? In other words, if they know what's expected of them, maybe they'll follow suit and abide by it, right? And then when it goes wrong, or maybe it goes right, we can reward them, okay? But if it doesn't go so well, we talk about discipline or discharge, which is why we're here today. So I want to talk about quality of communication because I think that it's oftentimes a, sort of do as I say, not as I do, right? As leaders, if you're in this room, I'm guessing that you're involved in discipline or discharge situations. Maybe you're an HR manager, maybe you're a business owner. We have to make sure that we're actually modeling the right behavior and communicating with our folks in a variety of ways. And we're going to talk about how we do that. But I want to throw up a couple of rules of thumb here because I think, generally speaking, we tell our employees, look, if you feel like saying something in the workplace, we want you to ask yourself, would you say it in front of your mother? Would you say it in front of the CEO or in front of the business owner? And would you say it, would you feel comfortable being quoted as having said it in front of a jury? If the answer to any of those questions is no, don't say it in the workplace, right? So that's easy for us to say as people in the position of authority, right? When we're communicating with our employees and we're saying, hey, look, this is the behavior we want you to engage in. Here's the stuff we don't want you to say. If you can give your people just kind of a bite size, hey, here's a rule of thumb, maybe this helps guide their conduct into the future and helps avoid some headaches for you guys. So next I want to talk a little bit about policies, and nobody really wants to talk about policies in detail because they're boring, right? But we have to talk about, do we have them, do we not have them? A lot of my small employers are afraid of having employee handbooks, Couple of reasons. First of all, they can be expensive to produce, right? Because you don't want to make something, you don't want to produce a handbook that you get where you pull policies off the internet and maybe they're wrong. Maybe they have stuff in them that's not even legal. And so that can be a deterrent. Some people just don't want to be bound by anything. They want to be free to run their business however they can. But we all know, of course, that we still have to abide by some certain laws, right? So there are a couple of policies that you really want to make sure you have. You want to make sure you have an anti-harassment policy, right? We want to make sure we have a non-discrimination policy. And I think there's a whole laundry list. And if you touch base with me afterwards, I can give you some more detail on that. But I want to make sure that we understand, even if you don't have a policy manual, you're at least communicating with your employees regularly to tell them, hey, this is what we expect. We expect you not to discriminate against each other. We expect you not to discriminate against, outside vendors. We don't want you to harass people. This stuff seems like kind of common sense. But I would encourage you, if you don't have it written down, write it down, put it in front of them, have them sign it so at least they understand. And then you can say later, should you ever have to discipline or go so far as to terminate, if they file for unemployment, you at least have some evidence to show that you communicated with them, okay? So we want to do it. We want to make sure that we're conveying our expectations verbally, and also in a written format, the policies and the handbooks, that's written verbally. Performance evaluations. People think about performance evaluations as having to be, some large production that, takes a week at a time. It shouldn't have to. Regular feedback's okay. Let's just make sure that we document it, okay? So we'll talk about that too. So I want to talk next about the concept of discipline in general. Before we even talk about what goes into your policies, I think we all kind of need to be on the same page, right? So I come at this from a space where I think about performance as being something very different from conduct. Employee performance is basically the comparison of the employee's actions against some sort of objective or subjective standard, or their position. It's like not meeting sales goals or not meeting production goals or just generally not meeting your expectations. You see, of course, inherent in that is we've got to communicate the expectations in the first place, right? Okay, so then when we look at conduct, conduct's really the comparison of their behavior against a written or an unwritten standard or some sort of work rule. There comes that communication piece again, right? Because if we haven't told them what the rules are, then how are they going to be able to conform and conduct themselves in an appropriate manner? So conduct can be anything from threatening somebody harm or safety violations. Excessive gossip can be a conduct violation, right? I see some heads nodding. We have that sometimes. So when we look at whether or not we're going to discipline somebody, I think we need to take a look particularly at what have we communicated out to begin with? Have we been fair with them? This is really not the time to hide the playbook, okay? If we've got expectations, we want to let our folks know. And then we want to make sure that if they do something that we don't like, right? We do something that's either a violation of our policy, maybe it's a really big one, right? Like weapons in the workplace, I had a case last week where somebody called me and said, I've got a guy with a gun and he's shooting at our dumpster and he's on your premises. And I'm like, why are you calling me? Right? So that would be like a severe conduct violation, right? Okay. I hope that doesn't happen to any of you. It all turned out fine. The sheriff took him away and it's all good. He did get fired though. Okay. So that's a big one, right? That's a severe conduct violation. Maybe that warrants termination, and that kind of seems like, maybe a no-brainer. But if you have these little things, right? Like maybe you have an employee who forgot to keep you in the loop on something. They forgot to give you a report or something like that. We can only really fairly counsel those people and mete out some sort of discipline or go so far as to terminate if we've actually told them in the first place that that's the expectation. So when you're imposing any sort of penalty against your employees, I just want you to think twice about whether or not the punishment fits the crime, right? So in the case of, the guy who's shooting at the dumpster, right? I mean, termination, that fits. If they were to have given him a slap on the wrist and a warning, maybe that would have been okay, but it kind of depends on the circumstances. Who's the employer? Is it an employer, is he employed at the shooting range, right? Where it's okay, where it's, it's been stated that it's permissible to bring, guns to work. So you've got to kind of think about that and just be careful, because you want to be thinking about how it would play back if you ever have to testify in front of a jury, or if you ever, have to testify at an unemployment hearing and go through that process. So I want to talk next a little bit about investigations and some best practices. And this is something that I think we get really, really caught up in how how we're trying to drive our business forward, and we get caught up, not wanting to deal with these types of things, and then they kind of fester and they blow up, and then bad things happen, right? So when we talk about investigations, it's kind of a big word. I'm not talking about like the FBI. It does not have to be a federal investigation. To me, an investigation really is just a conversation, but it's a little bit more in that it's a tracked conversation. So if somebody comes to you and says, I feel like I've been sexually harassed, and here's the person who did it, and I feel like the company ought to protect me. Red flag, right? That's an easy one. We know we have to look into that. But what if somebody instead comes to you and says, Mike made this comment to me, he sits in the next cube, and he made this comment, and I don't even know if it was directed at me. It was just sort of in my vicinity. I think he might have been talking to his buddy on the phone, but I overheard it, and I just found it offensive. But I really don't want to tell you what the comment is, and I really don't want to blow this up. What do we do in those situations, right? Even that situation warrants a further look. If somebody feels like they are coming to, you in your capacity as, being in charge of human resources or as the owner of a business, if they're coming to you with some sort of complaint, even if you're not the one who is supposed to be the one ultimately receiving that complaint, send it up the chain. Somebody's got to look into that stuff, because the longer those things are left to kind of sit and fester, the larger the potential liability is. We talked about that first situation where we had that manager who was making the comments about the employee's chest and who was, talking about, strippers in the workplace, things like that. These isolated incidents can be kind of wrapped up in a neat package and really can create some major liability. And it's also kind of a civility issue too. You want to make sure that your employees are treating each other with general respect. So if you do happen to get a question or a comment about, somebody's conduct or performance in the workplace, we have to look into it. Unfortunately, as an owner of a business or as somebody who's trying to drive productivity or drive sales, it means you kind of have to take a step back, right? And you've got to deal with this on the side, which is not easy, and I completely acknowledge that. So you have an option. You can outsource some of that stuff, and we'll talk about when you might want to do that. But if you're going to do it yourself, we want to make sure that you're thorough, okay? So when somebody brings a complaint to your attention, if you're the one responsible for investigating it, if the buck stops with you and this is landed in your lap, you want to make sure that you get a complete statement from that person. You want to know who's involved. Were there any witnesses? Did somebody else overhear it? I find that at the conclusion of these investigations, even if it comes down to, well, it's more of a he said, she said kind of thing, there always seems to be another witness. There's always something else out there that can help you make decisions. So keep asking questions, all right? We want to make sure we're being really thorough so that we have all the information before we go ahead and make a decision. The next thing I would say is, to the extent that you can, try to be independent and neutral when you're talking to these folks. I think employees sometimes are reticent to come forward with complaints because they're afraid that they're going to potentially be retaliated against. Maybe they're concerned that they're going to be frozen out of meetings, or they're going to be left off of an email chain on something that's important to them. Or worse, they're going to be terminated or ostracized in the workplace. I think sometimes That's a natural reaction that folks can have, but we can't do that, right? And so if you're the one charged on behalf of your business with looking into these things and investigating these types of complaints, you want to make sure that you can tell the person who made the complaint to you, hey, look, I'm charged with this duty, and I am going to carry it out to the best of my ability. I want the facts. I just want to get to the bottom of this so we can figure out a way to move forward together. So we want to make sure that we're as neutral as possible. Now, I recognize that as a small, if you're a small business owner and you have limited resources, that might not be possible. And it might even be, the kind of thing where you act as in a neutral manner to the best of your abilities, and still the employee is going to see you as, you're still an employee of the company, right? So you still kind of represent the company. That's okay. We work within the resources that we have. Our goal is just to try and make sure that we're acting in a manner that doesn't give any sort of rise to a claim by the employee that, we were somehow favoring one side or the other. We want to make sure that we're organized, and this, I think, is probably the toughest part, frankly. When you are looking into these issues, keep a log. Keep a log of who you talk to and what time you speak with them, the amount of time you talk to them, because that can become important later. I mean, we've seen situations where, the HR person gets put up on the stand and they don't have any notes, but they just say, well, yeah, I talked to so-and-so and I talked to so-and-so. And their testimony would have been so much more robust, so much more believable if they could have said, yes, I talked to Mike at 5:30 on Friday afternoon, and we spoke for approximately 2 hours, and here are all the things that he told me. So I think that if you can stay organized through the process, it will also help you in the long run really ferret out what happened so you can make a better decision. I want to talk a little bit about making sure when you do these investigations that your scope is defined. And this is a big one for me. I do independent investigations myself on behalf of businesses, and it's even a struggle for those of us who are trained in conducting investigations to keep a narrow scope. When a complaint gets brought to you, inevitably you're going to uncover other stuff. It's just the nature of people, I found. And I think, when somebody comes to you with a complaint and they say, okay, I feel like I'm not getting paid as much as John in the department next to me, or as much as John in the cube next to me, and we're doing the same thing, and I feel like you need to look into that. Oh, and by the way, Bethany over in purchasing, she's got this picture of a Chippendale up in her cube, and I think that's offensive too. What do, right? Now you get two things you've got to look into. This is where the documentation piece comes in handy, right? Because then at least you can kind of separate out and prioritize. But keeping a narrow scope is really important, because if the purpose of the initial claim is to figure out, whether or not there is an actual Equal Pay Act violation, then we got to run that down. And then secondarily, obviously you're going to have to follow up with Bethany over in purchasing about the Chippendales picture and whether or not that's offensive, and run the gamut on that. But you've got to make sure that you're organized enough to at least take in the information and then do something with it. Because I think at the end of the day, the worst thing that can happen is if you have to get up on the stand and testify to having received information that potentially creates liability for your company, but also having to testify that you didn't necessarily do anything about it. So then when we look at, we've got our defined scope, we're going to conduct this great thorough investigation, we're going to be as independent and neutral as possible, we're going to be organized, we got to keep documentation, right? We have to keep notes on this. And it's as much for your protection down the road if you ever have to testify at a court hearing or a trial, or in front of an agency, as it is just a way for you to facilitate the decision-making process, right? If we don't keep the facts, we're not going to have all the materials in front of us to make a good, solid disciplinary or discharge decision. So I want to talk just a little bit about when it makes sense to hire somebody outside. So if you are in an enterprise that has multiple employees and you have, for example, history between the person who's making the complaint and the HR manager. So if there's no way the HR manager can be neutral because this person's made a complaint against the HR manager in the past, or if you have a situation where the complaint actually involves the HR manager. A lot of times the HR manager is intimately involved and kind of has the keys to the kingdom, right? They understand the personnel decisions. They have access to all the wage information. They know who's making what and who's given what job duties and why they were given those duties. They don't always actually have the keys to the kingdom. They might not be the ones making those decisions, but they have access to the information. So sometimes it's perceived that they're the ones making the decision, therefore the complaint is made against them. When in actuality, it's really more of a situation where the complaint should be made against the company. But if you've got a situation like that, where you've got a complaint involving an HR manager or an HR manager who's somehow impaired with regard to her neutrality, then at that point, you're gonna wanna work with your attorney and try and get somebody on board to do an investigation outside of the company. Somebody else that can just come in with a fresh set of eyes, do the interviews, provide you with a short report saying, here's what happened in this situation, and that draws a conclusion, right? Anytime the complaint you receive involves a C-suite executive, and I use that term really broadly, so anytime it involves the owner of the company, anytime it involves anybody up on your higher level of management, that's going to be really, really tough for an HR person or for somebody who's responsible for receiving complaints to investigate, right? Because it's difficult to speak truth to power. And the person who's making that complaint probably knows that. So in a way, you almost have to look at it in a hierarchical sort of scheme, because if you've got, HR manager who's responsible for overseeing all of the employees, and making sure that they, adhere to the policies and are acting the way that they should be acting, and they're reporting up the chain, to the business owner or to somebody else, who's got some sort of power or influence over them, influence over their compensation, we want to make sure that that HR manager is not the one doing the investigation, because they're not going to be able to be perceived as being impartial. And it might be that they might not be able to be impartial for fear that whatever response they give as a result might tick off their boss, right? So if we go through, if the HR manager investigates in those situations and they find out, oh yeah, we've got a super serious sex harassment situation going on here, and they report that up the chain, that might not be very well received, and that person knows that. And so in that situation, I think it probably makes the most sense to just get somebody from the outside. Also, if you've got something that's just too big. So I gave the example earlier about somebody who made a Pay Act claim, but then they also complained about the Chippendales poster, which actually did happen to me. In that particular situation, though, it was even more than that, because the person who made the complaint, and she did actually have a founded equal pay complaint, the employer just really hadn't been paying attention to the gender decision when implementing their pay scheme. And it turns out that, these two people were doing equal work and they weren't getting paid the same. And the employer went on to remedy that. But it was interesting because in that situation, the employee who came forward to make the complaint not only had the complaint about the Chippendale poster, but she also started kind of ticking off all these other things in the workplace that were concerning her, some of which were actionable, discriminatory type activities, some of which were just like, I don't like the pop in the pop machine. If you've got a situation where you've got multiple things that you've got to look at and they're all pressing, then you might want to get some help. Otherwise, if it's just a one-time thing and if you feel like it's something you can contain, then go for it. Okay. So we're going to talk next a little bit about documentation. So maintaining fair and accurate documentation, it's like a sword and a shield, right? So it can serve as positive evidence in a lawsuit in the event that you're accused of retaliation or wrongful termination or discrimination. And I've got some goals that I've included in here, and I think this is probably the most important thing with regard to documentation. So your documentation should basically guide your employee to compliance, right? So if we're looking at a situation where maybe you haven't received a complaint, but maybe you're perceiving some performance problems, right? Maybe your employee they're just not selling, right? They're not selling the volume that you want them to sell of your product. If you do your documentation in a positive way, you should be able to help guide them to compliance. So your documentation should set forth, here's the standard, here are some steps you can take to reach this standard, but this is obviously not exhausted. You kind of need to come and meet us halfway. You should also look at your documentation as a record of the communication between you and your employee, right? If you have good documentation, if you have any documentation, I know this is where folks mostly fall down, and I completely understand, don't get me wrong, but it shows that you actually did reach out to the employee, you spoke with them about it, and now you've got a record, and hopefully that record's contemporaneous, right? Made at the same time that it all happened, so that gives it a little bit of an indication that it's reliable. And then it also shows that we acted in good faith. We don't just throw our policies out there and kind of hope for the best, and then we're just going to give you the axe if you don't meet them. It shows that we're trying to help our folks along. So I've got a couple of rules about disciplinary documentation that I hope makes it kind of fail-safe, right? So when we put together our documentation, we always are thinking, if we're a business owner or if we're charged with this large responsibility of managing employees, we're always thinking about how we're going to protect our company, how we're going to protect ourselves. If we can follow these steps and make sure that the documentation we're putting together is really concise and it's consistent each time, then this should help kind of inoculate you from some of the difficulties that you might have down the road when you're trying to justify why you made the decision you did. So we want to make sure that we're stating what the policy or the rule is that the employee has violated, right? We want to state it clearly, point them to the page of the handbook, put a copy of the policy, just screenshot it and put it in the notice. We want to clearly state what the conduct is that we think violates the policy, or if there's some sort of performance issue, what the performance is that the lack of performance that's not meeting our expectation. If we have counseled the employee about it in the past, and this is where those people who have to do unemployment hearings should take note, right? If we have had to counsel somebody in the past about doing this very same thing, we want to put it in the disciplinary documentation, okay? Because that serves as evidence that, look, they had their one free bite at the apple, and now we have to discipline them for it. And then we're also going to say, look, if this happens again, maybe we have a 3 strikes and you're out policy. If this happens again, you're gone. We want to make sure that all appears in there. We also want to make sure that the statements we make in the documentation is factual, and I have a good example for you for that as well. But we don't want to judge people, right? We just want the facts. We want it to be kind of boring, okay? This does not need to be a novel. It needs to be really straightforward. Bulleted lists are A-okay here, okay? I just don't like the speaking in absolutes. He always comes in late. He's never met his sales goals. He never comes in on time. Those types of situations, that language gets you into trouble, especially if you end up having to testify at some point, because inevitably they will be able to find the one time the guy showed up on time, right? We want to make sure that you're objective, that you are looking at this from more of a neutral position, like, hey, here are the facts. Here's the policy, here's what happened, here's why we're doing what we're doing. It needs to kind of pass the smell test, right? We've got to make sure that we're describing the conduct of the employee. If the employee is engaging in some bad behavior in the workplace, let's not just say they're a bad guy, okay, or they're a bad actor. Let's make sure that we're putting in there, here's what they did that led you to the conclusion, right? Like they left their smelly stuff in the refrigerator for 6 weeks, okay? We want to make sure that we're We're very clear about the actual activity that took place. We want to describe the impact that their behavior or their conduct had on other people in the workplace. Maybe you received a complaint, maybe you didn't. Maybe it's a potential for future complaints that you want to note in there. That also helps them to understand what the impact of their conduct is on other people. And sometimes people, you know, they need to see it in writing as well as hear it verbally. So I think that can help there. We want you to be very, very specific. Give examples of what it is that they've done wrong. What's the conduct? Where's the beef? What's the violation? Okay. And then the last thing I have on here is do it contemporaneously. So we want you to do it at the same time. And I know that's the hardest part, right? Because again, we're trying to run a business. But if you can at least have it done, you know, within a short period of time after it happens, after the offensive conduct or the complaint comes in and you've investigated, let's go ahead and do it as quickly as possible. We're basically trying to show here that as an employer, you acted in good faith, right? You treated your employee fairly, and you know, you are setting expectations as to what is going to happen in the future if there's another violation. So here's an example of some bad documentation. My colleague put this together and I just thought it was too funny not to include. So bad documentation would be like a statement. Earlier this month, Betty was wasted and I suspect she has a drug problem and needs rehab. Good documentation looks something more like, on June 12, 2017 at approximately 2 p.m., I observed Betty Smith walking in an unsteady manner to her office. When I walked into her office, I could see she stumbled to get to her chair. When I asked Betty if she was okay, she stared at me and slowly slurred, that's a good question. I could smell alcohol in her breath and could see her eyes were bloodshot. I immediately told Betty I was suspicious she was under the influence of alcohol or drugs. I proceeded to instruct her to gather her belongings, and pursuant to our policy, she would be required to undergo a test to determine whether she was under the influence at work. Okay, so those are two, they get the point across the same way, right? I mean, it's very, very easy to be like, Betty was drunk at work, okay, and leave it there. But if we can give some context, it's much easier to establish that, in fact, yeah, it sure does sound like Betty was under the influence of something while in the workplace. Because the first statement, Betty was wasted, what's wasted mean? Wasted means different things to different people, right? So it's much harder to pick apart when you have those very, very factual descriptors. It also kind of lends itself more to a more neutral analysis, which I think helps. So my number 5 is don't retaliate. And here's why it's number 5. First of all, it should be number 1, but it's number 5 because I feel like we have to talk about all those other things before we can get to the retaliation piece. What I often see is that employers do an amazing job of putting policies out there and counseling their employees and saying, look, here's the behavior we expect of you, and we want to make sure that you abide by our company's mission and our principles. And when the employee, when they get a complaint, whether it be a harassment complaint or a complaint of discrimination, they look into it and they get to the bottom of it and they figure it out. And they talk to the employee who's the offender and they discipline them or they terminate them. They do all of the right things. And sometimes they'll even document it, which then I'm like, hey, it's like Christmas. But if they don't do the next step, which is not retaliate against the person who made the complaint in the first place, it all goes away. All that goodwill you built by doing everything right in the first place is essentially extinguished. And we're seeing a lot of retaliation cases right now because the natural instinct when somebody makes a complaint against you or against your business, I think is to, you kind of turn in and you're like, well, okay, fine, we'll investigate this and yeah, we'll fix it. But, I'm just frankly offended that they made the comment against me and I'm going to take it personally. And so what happens is, maybe you leave them off the email chain like we talked about earlier. Maybe you're freezing them out of meetings. Maybe you reassign their duties. Maybe you send them to Timbuktu to do sales instead of, Palm Springs, right? It's all of those types of actions that could be seen as retaliatory. So we want to make sure that we're taking steps after the fact, after we've, gone through our investigative process and we've issued whatever disciplinary action needs to be issued. We're circling back and we're making sure that if the offender, the person who is complained against, is still in the workplace, we're telling them, hey, you know what? Here's the disciplinary action. Maybe you get a suspension. Maybe we're going to reduce your pay, or we're just going to put you in a box over here and make you not talk to people. Whatever it is, make sure you're also telling them, hey, you know what? I know you're probably ticked off that you got called into the principal's office, but we can't retaliate. We don't permit that. And then you also have to make sure that you're telling the person who made the complaint in the first place, hey, we don't tolerate retaliation. So if you see or if you feel like you're being retaliated against, we want to know about it and make sure that they understand that you're an open door and that you're a resource for them. So I put just a couple of examples up here, and I think I want to make sure that I leave enough time for questions. But so when we talk about retaliation, I put together a few slides that are sort of just, do you know what to do, right? So an employee makes an internal complaint about safety. What do we think we do there? You receive a complaint about an employee about safety. Do we think that's a big deal? Maybe? Yeah. Okay. That's good. It's positive. It is, right? What should we do? We should look into it, right? We're going to have to get to the bottom and find out, is it really just, somebody left a pop can on the floor in a production area and that's unsafe because somebody could trip over it? Or is it that the guard was ripped off of a machine and somebody could lose their hand, right? We want to understand sort of the general scope. It's not just for protection of the business, it's for protection of your people, because I'm guessing most of your businesses can't run without your people. So then if an employee makes a complaint with an agency, what do we do about that? Do we look into that? Yeah, we probably have to, right? Are we going to retaliate against the person who made the complaint, even if they're still an employee? No, we're not going to retaliate against them. That's where you kind of have to override that general instinct, and those are the toughest situations. When you do have somebody who, for example, files a complaint with the Iowa Civil Rights Commission and says, you know what, my employer is discriminating against me because I'm a homosexual, and here's the laundry list of things they've done. Oftentimes employers will get those complaints, they'll receive them, they'll look at them and go, we had no idea this was going on in our workplace. Or they'll say, that's not how I remembered it. The instinct is to then, of course, charge over to that individual and say, you made this complaint, you're making my life miserable because now I have to respond to it. We can't do that. We have to be very circumspect about how we act and how we treat those people once they have made a complaint. And then obviously, I neglected to mention earlier, but the person who made the safety complaint, we don't want to retaliate against him either. So what if the employee's complaint turns out to be inaccurate? Or it's just plain fraudulent, right? There's a difference between a fraudulent complaint and an unfounded complaint, right? So before we consider discipline or discharge, we probably need to assess whether or not these complaints have been made in good faith. And the time that I see this come up most often is when, say somebody's on the bubble, right? They've had some performance or conduct issues in the past. They know that it's not looking good for them, and they're probably on their last chance with the employer. And maybe they've done something. Maybe they've, ticked somebody off, or they've said something in the workplace they shouldn't have said, or they're not meeting their goals. So they make a claim, right? In hopes that that claim will serve to save their job. When you are, and I think it goes without saying, we got to look into it, right? I mean, you can't just write it off as something that, they're just doing this to save their job. We're just going to go ahead and fire them anyway. You actually do have to legitimately look into that claim. But if you, in your best judgment, come to the conclusion that it really wasn't made in good faith, that it really was, in fact, made for the sole purpose of them trying to keep their job when they probably otherwise shouldn't, then I think you can consider that when you're making your decision whether or not to discipline or terminate. So unfounded complaints that, ultimately there's no basis for, right? Like I think that there's a pay discrimination or pay discrepancy, but at the end of the day, when you get to the end of your investigation, you realize that there really isn't. that would be considered an unfounded complaint. It's not fraudulent. It's not made in bad faith. The law does not protect bad faith complaints, but it does protect unfounded complaints. So I wanted to put a little bit in here about harassment and discrimination, only because it just seems so topical and it seems like the topic of the day, very, very popular. So an employee who says that their pay raise or discipline was unfair, we talked about that, right? We're making sure that we're investigating those and we're not retaliating against them if there is a good faith belief that it is in fact unequal. If an employee says that their coworker was rude, that's always a tough one, right? When does rudeness rise to the level of harassment? That's one that you're probably going to have to take a really, really close look at and figure out, okay, if you've got somebody in the workplace who's a bad actor or like a bad manager, right? Somebody who says things just without thinking. It might be that there's no actual like legal liability there, right? I mean, you might just find out that the person is just not a great coworker or kind of a jerk in the workplace. We have those. Every business has good managers and not so good managers, and good employees and maybe not so good employees. And hopefully we get, our bearings and can ferret all of that out. But just because something doesn't rise to the level of legal liability doesn't mean you shouldn't still do something about it. If you've got somebody who's being rude in the workplace, obviously, let's go ahead and talk to them about it and see if we can remedy that behavior. Managers who see inappropriate behavior, obviously, they should be running that through human resources or through whoever it is that's charged with making sure that those activities are investigated. If an employee mentions religion as a reason for not being able to work a shift, what do we think we do there? We have to look into that too. There are religious accommodation requirements that we have to in most cases follow. So you're going to want to make sure that that gets run up the chain. Okay. How am I on time? All right. So pay issues. What can I do with an employee's last paycheck? Can I charge my employee for uniforms? These are all things that can generate some sort of discord in the workplace. You can get complaints about these things. If you do know what to do, fantastic. If you don't, call someone who does. Call the attorney you're working with. Get a quick answer. It is so worth it to make that 5-minute phone call and incur the, whatever minimal charge it is, than to deduct from an employee's last paycheck and later get sued and have to pay, not only what you owed plus liquidated damages and attorney's fees. But we also want to make sure that when we're looking into these issues, right, we're not discriminating and we're not retaliating against these folks. The last slide I have, I think it's the last slide here, is on Fair Labor Standards Act. Do you know what to do? What can I do about unauthorized overtime, pay, discipline? Employees want comp time. An employee who's salaried or exempt, but they have poor performance, and we keep taking away their job duties. Like, is this a problem? These are all issues that you're going to want to elevate. You're going to want to look at closely. You're going to want to do your investigation, document outcomes, okay, and make sure that whatever decision you make, especially in some of these, kind of touchy situations, like, removing the job duties and things like that, that you're consulting with your employment counsel or somebody that you've got in-house that can serve as a resource for you. So I see that Christina's standing up in the back, which I think is...
So we have a couple minutes for questions, so I want to make sure that we leave time for that. So I will come around with the mic so that our people watching in can hear the question as well. Yeah.
Hi, Bernie Stone, New York Life. Thank you for your expertise today.
You're welcome.
Are there any particulars in Iowa law that trips businesses up, either because it's very common that they just overlook, or is there something that protects businesses more often than not? I'm a transplant, obviously.
Oh, sure. Well, welcome to Iowa. It's good to have you. So yeah, the question is obviously whether or not there are certain things in Iowa law that trip businesses up. I would say one of the big things is the deductibility from paychecks. Iowa Code 91A, if you're new to Iowa, I'd say take a look at that. Because it basically sets forth what you can and can't do with employee pay. In Iowa, we do not like it when employers mess with employees' paychecks. They have to set forth, employers have to set forth the expectation of when employees are going to be paid, the schedule, and we're very specific about deductions. And so if you are in the situation where you're looking to terminate an employee and perhaps you've loaned them money or they owe you for something, you cannot just go ahead and deduct from their paycheck on, take it out of their last paycheck. We have some pretty specific rules surrounding that. So that's kind of the first one that comes to mind as a peculiarity. I'm sure there are others, and I'll think of them probably after we leave here, so maybe we can connect later.
Another question.
With the documentation, do you always have that signed by yourself and the employee?
That's a good question. Do you sign the documentation and try and have your employee sign? Yeah, in a perfect world, that'd be awesome. Doesn't always happen, right? So when I see employers, the ones that kind of do everything by the book and have, a really solid process down, they will typically have, whoever conducted the investigation or amassed the documentation, put it together, sign off on it. We encourage you to include a line for the employee to also sign off on it. Sometimes they will. That's great. We like that. Sometimes they won't. Or sometimes they'll say, I agree with none of this. I'm not signing. That's okay. Just keep a record of it.
Another question? Yeah, John.
Hello. Somewhat unrelated, but seeing as no one's asking anything. So for my situation as a small LLC, I almost do everything where I contract it out. But there are still some rights and responsibilities when I do that, aren't there? And could you speak to that for a moment?
So hiring a contractor versus hiring an employee?
Well, not just a contract. No, I might be working with some, what they call the gig economy, right? Where I'm not hiring a contractor to come in and put in a kitchen for me, but I'm hiring designers or marketing people or things like that, and they're sending me a monthly bill or that kind of thing. But I would still think there might be some responsibilities that I have, possibly.
Yeah, I think, the biggest one that comes to mind, at least, just sort of generally would be, to the extent that you have an anti-harassment policy, making sure that they have a copy of that. I think that's important, especially if they're going to be coming into your workplace. If you've got other people in your workplace, yeah, that's one in particular I think is definitely something you'd want to look into.
I know one question that I get a lot working with entrepreneurs is no call, no show. Did they quit? Do you write them up? What happens with that?
Yeah. And it's tough because I think you have to look at those no call, no show situations on a individualized basis. Why are they not coming in? If they're not coming in because they have some sort of disabling condition, I think you need to know that. You can terminate for 3 days, no call, no show. That's the unemployment standard, but it really has to be a case-by-case analysis because, and sometimes we can't even find folks to find out. And if that's the case, then I think you're probably safe. But yeah, it really is an individualized inquiry.
Other questions? You got a free attorney here right now. Yeah, it was like somebody asked to have a question.
Christina, what are you doing?
When you're talking about
Your terms and condition page, Beth.
Right.
pay deductions,
Yeah.
can you go over some of that? I know you can't go over the whole thing, but
Yeah, so I'd first say I'd point you to Iowa Code 91A. It kind of reads like stereo instructions, but it's not too bad. You can kind of pick through it. But the thing that I hear a lot about, like returning of company property, right? So say we give an employee like a laptop and they don't return it. I think the instinct is always to, well, I'm just going to take it out of your last paycheck, right? And you're just going to have to deal with it. And that means your pay is going to be reduced. But if you're going to do something like that, you have to get their permission first. And so sometimes they'll give it to you. Sometimes they'll say, yep, you know what, I want to keep my laptop. Here it is, wipe it for me, take it out of my last paycheck. Sometimes you'll never hear from them and they're in the wind. And if that's the case and you can't secure written permission from them, then I wouldn't do it. Because I think it creates some exposure for you in terms of a pay violation. If they take your materials, yeah, you can go that route, sure, yeah.
Instead of just deducting it out of their pay, can you just say, hey, I'm going to hold on to your paycheck until you return our property, and then?
We can't. You cannot. You cannot. The question was, instead of just deducting from pay, can you just hold on to their paycheck, essentially hold their check hostage? Yeah, we can't do that. I mean, you could, but you just run the risk of them getting a savvy wage and hour lawyer that can spin it into something, and ultimately you end up paying for that lawyer's attorney's fees as well as your own, which nobody really wants to do that. Yeah. So I think that's a really good question.
Can you repeat that?
Yeah. If you, so the question is, if you had it in your employee manual that all of these things need to be returned upon termination, can you then take it out of their paycheck? I still think the answer is no, but I like that. I like that provision in there, because that would give like your attorney or something to work with when you go ahead and you file a small claim against them in small claims court to try and recover, the asset or recover the funds.
Okay, last question.
I was just wondering about any tips for dealing with attendance issues for business less than 50, but somebody who just constantly is unable to show up to work, and then they'll bring in doctor's notes. If they always have a doctor's note, can you do anything about it?
That can be a really complex question. The question centers around, what do you do with people who just aren't showing up to work, but they're coming in with doctor's notes? There are people that game the system all the time. I'd say, I think you need to be a little bit careful if they are coming in with doctor's notes, because you probably need to do some sort of disability analysis before you make any decisions. But I do think there are circumstances in which you can discipline those folks. I mean, especially if attendance is an essential function of the job. So I would say talk with counsel about it, because it can get a little bit sticky. But I think there are some things you can do. Yeah.
So, well, let's thank Beth for being here today and donating her time. And then there on your table is surveys and flyers of our next 3 classes. If you can complete those surveys, and especially if there's more topics you want to learn about, that helps me continue to build the programming for you and bring you what you're looking for. And then a couple events coming up I just wanted to make note of. On February 2nd is our First Friday series. It's our Female Entrepreneur series, where we actually simulcast out as well, but we interview a female entrepreneur in the community of her journey. This month will be Nicole with Preservation out of the East Village will be here to be interviewed. And we team up with the Women's Business Center, so make sure you check the location, because sometimes they're here, sometimes they're out there. We do have, it's hosted twice a year. On February 22nd, we have Capital for Your Business. And this is a class that if you are seeking any traditional funds via a bank loan, state funds, anything like that. It's a half-day class. We will walk you through the process of what banks are looking for. You'll leave with a business template, a cash flow template, everything that you need to get you through a bank loan very quickly. It's worth the one day to come in. The formulas that we use have been put together with banks. They love this class. So if you're interested in seeking traditional financing in any way, it's worth the time coming in. And then our next top 5 class will be back here on February 28th. And it is all about securing your data. So small businesses are one of the top people to be hacked recently. They will go after because they know your data is not secured. So if you're interested in that at all, Ariane IT will be teaching that class on February 28th. So thank you all for coming. We look forward to seeing you at another entrepreneur event very soon.
Not bad.